Do that. So welcome to this webinar. We are going to try and keep it very pertinent and to the point. Should be about 35 minutes. So myself, my name is Robert D'Souza. I am the head of data privacy at Chaucer, and my associate Paul Gillingwater, who can briefly say hi. Paul.
Thanks, Robert. Yes, I'm Paul Gillingwater. I'm an associate partner responsible for data protection and also cyber security. So we're happy to talk about both of those angles, and I'm sure that equally they're both important to our listeners.
So just to do some housekeeping before we kick off, this session is being recorded for posterity. So if anybody has an objection, please can they let the presenter or moderator know? That would be good. We are also taking questions, so if you feel that you don't want to come online and ask a question as we talk, please feel free to write a question in the question box. There's no need to put in a name or an affiliate if you prefer not to, and just put the question. That would be fine. So moving forward very quickly, so just a little bit about Chaucer. So we've been, Paul, if you wouldn't mind flipping the slide to the next slide. So we've been around for about 30 odd years, supporting clients in all different shapes and sizes in relation to business change, transformation, data protection, and security. And we have inroads into the utilities and energy sector with one of our large clients, BP, who we've assisted over the years in many different areas, including that of data protection and compliance. Within Chaucer, we have a dedicated team of data protection specialists, including Paul and myself. We are based in London, not too far away from Monument Station in the city, and we also have offices based in the USA as well, within New York and Houston. So that's a very quick overview of the group. Please feel free to Google us and have a look at our site and our services. But what we'll move on to now is looking specifically at areas within the energy sector that we feel we've dealt with a lot of questions around these bullet points in various guises for various companies, including energy and utilities. So Paul and I thought we would kick off with picking a couple of the sort of main issues that we come across, and give some outline and some view as to how we think that affects data protection, and how data protection affects what utilities companies are now faced with in relation to treating customer data. So Paul, did you want to kick off with a question or one of the bullet points that we could start discussing?
Yes, thanks, Rob. I just wanted to mention that we've prepared a white paper which is available for free download. You don't need to register again. Through the handouts interface on the GoToWebinar, you can download that white paper and have a look. And that will go into some more depth on some of the topics we'll be talking about this afternoon. So I just want to start off. Rob, can you tell us what happened on May 25th this year? Why is it a big deal? What changed? Why, from my perspective, why is privacy now mission critical?
Well, on the 25th of May this year, if people weren't aware, the new General Data Protection Regulation came into play within the United Kingdom. Equally, I think a week before that, the new UK Data Protection Act 2018 also kicked in, and it is deemed by the government that both these bits of legislation run in parallel together. The UK Data Protection Act does adopt about 90% of the GDPR. The remaining 10% is split out into dealing with the security services, law enforcement, research, and employment, which are the main sort of areas that it changes from where the GDPR is concerned. And funnily enough, we also still maintain the original UK Data Protection Act of 1998, as not everything within that act was moved across to the new UK Act. So we have 3 acts that are in play in relation to data protection. Why did these things come into play? Well, one of the main reasons why they came into play was to harmonise data protection across Europe. And what I mean by that is that there was a standard set by all the member states as to how our personal data would be protected, and it would carry some uniformity across Europe. It was deemed also as very important on the basis of the 1998 Act not really carrying enough clout in relation to the protection of personal data. So the new rules and the new regulations and the new statutes put a lot of power into the hands of us, the individuals, in relation to how our data is treated by not just utility companies, but by any company that has access to our personal data, or we choose to give access. Expanding, I expect, on the concept of choosing, and why privacy is now becoming a very, or should be seen actually as a very mission critical element of your business, is because of the credibility of the data that you hold. Currently, many companies hold quite a lot of personal data. Within the new regulation, there has to be a purpose as to why you have to hold that data. And you have to offer a number of options to data subjects in relation to how that data is treated, how it's updated, how it's removed, how it's added, what you do with it, what you are allowed to do and not allowed to do with it based on the consent that you get to use it. And by not complying to this, the ICO, who is the supervising authority in the United Kingdom, the Information Commissioner's Office, can at any point require an audit of your systems and your services and your policies, processes and procedures in data protection, and can levy fines as and when it deems necessary as an outcome of that audit. Just to briefly conclude on that point of fines, the ICO aren't there to fine anybody. They are there to ensure that we comply with the law, and that we comply properly with the law and have the right steps and measures in place to protect the personal data. And the audits that are carried out by the ICO normally come out with a number of recommendations to companies to which they should equally adhere to. So the importance, I expect, of privacy now is that it needs to be seen as important as running any other element of your business. It may not bring you revenue in relation to bottom line, but what it does give you is the avoidance of reputational damage and the avoidance of fines. So clearly, the concept of data protection should be moving up in the boardroom in relation to how that personal data is treated moving forward.
Rob, can we get a little bit more specific in regards to the responsibilities or the challenges that people in the energy sector are finding? Particularly, I think we've talked about this. You've talked about the Hive, that the Amazon Alexa, Nest devices, yes. Hue, all of these new devices are being installed in people's homes. They're collecting data about usage. They're collecting potentially sensitive data. What sort of challenges are energy companies facing in this regard, and what do they need to do to make sure that they're appropriately dealing with all of this data they're collecting?
So you're right, the world is moving forward, and the Internet of Things and smart devices in the home are becoming somewhat of a norm. And you talk about Hive, Amazon Alexa, Nest, looking at the elements of Hive and Nest, for example, and smart metering, there's a lot of data being captured in the background of usage. how much energy is being used, and also in relation to things like Hive and Hive cameras, it's capturing and recording physical images and video, linking it with other elements in the house, such as Alexa from Amazon. The amount of data being collected on a personal level by a business is huge. That poses a couple of issues. The first issue is a data subject wanting their data back, or a data subject wanting to know what data is held about them. And the second is the ability to port that data from one place to another. And I expect the third is ensuring the security of the data being held of the individuals who have these smart devices in their home. If you take one subject at a time, if you take the concept of knowledge and the issuing of a subject access request, which is a request from a data subject to a company asking for what data is held about them, one can also then define the concept of what data is. It's a bit of an ambiguity within the regulation as to what is construed as data or personal data. There are companies within telecoms industry that consider personal data being your name, address, email address, and phone number, i.e. the data that you supplied them when you took out your phone or your mobile phone agreement. And then there is a further definition of data as everything that is held about that individual that can be identified by to that individual by some form of identifier. So your customer number, for example, for your energy bill or your utilities bill, your customer number will hold a huge amount of information about you. And as you move into the world of smart metering, it will also begin to hold maybe audio and video. So the ability to actually be able to access all that information in a cohesive and I expect non-expensive manner is down to the way that systems will be configured in the future, and how you will use systems and architecture and cloud services to be able to collate information in a single point where you are able to extract it very easily without having to spend months and months or weeks and weeks of time trying to piecemeal the data together from different systems. So the cause and effect there is an individual asking for that information, and the effect to the company is being able to access the information required efficiently, quickly, and cost effectively. And if the systems are not in place to do so, then transformation hits the arena. And of course, then you bring in the concept of privacy by design, which I'll let my colleague Paul have a stab at in a second. The second element is portability. So there is the ability now within the regulation for me to request all my data that you as a utility company may have held on me for the last 10 years, because I've not actually changed utilities. But what that allows me to do, and what that empowers me to do, is to go to another utility company and say, well, look, you've got 10 years worth of my history, of my usage. So clearly it gives you a very good pattern of what I do and what I use. And therefore we can do a better deal in relation to how much you expect me to pay a month based on my usage, because it's actual numbers rather than anticipated numbers. So portability for a customer is going to be key, because it allows them to get a better deal from their competition, because the data they have is more accurate and up to date. And the final one what was the last one that I mentioned, Paul? Portability was one. The last one is God, I've lost my train of thought, Paul. What was the last one that I bring up?
Well, I wanted to take up a couple of points, and while you're thinking on that, what else you want to discuss? One of the aspects for businesses which are dealing with members of the public, particularly if you're sending employees out into customer homes, is this question of what are your safeguarding obligations health and safety. And that's where, for example, a lot of companies aren't aware necessarily that if they're doing DBS checks on their employees in order to send them out into customer homes, those DBS checks contain sensitive or special category information, particularly concerning criminal record backgrounds. And it's that sort of thing which, particularly if you're processing large numbers of these DBS checks, that businesses realize they have an obligation to appoint a DPO as a statutory obligation. And talking of obligations, thanks for touching briefly on privacy by design, because unlike in the past, one of the big changes that GDPR is really bringing in is it's making privacy by design and default not just a good idea, but it is actually part of the law, where you have this obligation that when you're rolling out new systems, when you're migrating, for example, from your legacy systems, and of course that's challenging enough in itself, into the cloud, for example, you've really got to build in every privacy concept from the beginning as you're starting to go through your software development and life cycle. So privacy by design is really about putting yourself in the shoes of the individuals and realizing there are ways of protecting their privacy, which require you to take steps to do that as you're designing the systems. And it's not just about making the systems more secure. This is, I think, a misnomer that many people run across. While security is important, absolutely, there's no question, you also need to foster other principles like transparency of processing, purpose limitation. And particularly this is challenged when you're dealing with the marketing side, where your marketing teams might be realizing that, hey, we've got an opportunity to do some growth hacking here. Let's do that. And suddenly we get harvesting all of this juicy customer information, which will help us to grow our business. And you may not be aware that there are sensitive aspects about processing those large amounts of data. Possibly you're doing profiling and it's discriminating between different classes of customers based on their geography. You might figure, well, people living in central London, they can afford to pay more for their energy than someone out in Luton, for example. So profiling is certainly an issue that comes up. Rob, I wanted to ask, what do you think are some of the primary challenges that face the management of the energy challenges in terms of persuading their board where should they be spending their money? What are the most cost-effective ways they can be in asking the board to engage and fund projects in order to address these challenges?
Well, I think, Paul, you've hit one of the subjects, which is transformation. Many companies are spending a lot of time going through, the definition of digital transformation in some shape or form, and the ability to access data quickly and efficiently is probably one of the main topics, one of the main discussion points that I would look at board level. When you take into account the regulation covering things such as subject access request, portability, erasure, profiling, portability, all this is talking about is the gathering of data in a single accessible repository that is kept up to date, that is easily accessible when these things come in from data subjects. And by no means is the utility or energy sector any different from any other industry throughout the world, is that we all work with legacy systems. It's just one of those things. You purchase a company or you run your systems, and system change and transformation is vastly expensive. But when you look at then having to deal with the rules put upon us now in relation to how we protect and use data moving forward, which is never going to go away, and in fact probably going to become more onerous as people begin to understand the value of their data. The ability to be able to access that information quickly and efficiently will be somewhat a key. Without that, I think I think companies are going to companies are going to struggle in relation to the ability of being able to access that information quickly and efficiently, and know that what they've done is actually the right thing. So for me, when I look at boardroom, I think more of transformation, but not in relation to transformation from a technology perspective, but transformation from both a business probably the primary, and the technology sitting as an accompaniment, as a vessel to allow that business to function more efficiently, where data and access to that personal data is concerned.
Thank you, Rob. I just wanted to remind our listeners that there is the possibility to ask questions. We're happy to take questions either as chat through the interface, or you can actually talk to us and ask the question directly. No need to give your name. We respect privacy. So, and really that sort of thing is about building trust. And we know from working with a number of customers in this space that building and maintaining customer trust is essential. That's why we think that some of the tools in the toolbox for the privacy professional are very helpful. For example, fostering a culture of transparency and accountability. If there are any issues, those issues need to be reported and raised very quickly. And maintaining customer trust is key, particularly when you want to build growth. And really, startups and challenges in this space are all about the growth. The challenge is making sure that you don't run into some of the regulatory hurdles while you're attempting to grow your business. And that's definitely going to be something that's going to occupy the minds of people in this sector. Now, as you grow, one of the things that's growing underneath that is the value. And a lot of the value of businesses in the sector is tied up in the personal data of their customers, their usage behavior, their profiles, billing histories, and so on. And one of the things that's interesting is that this sector is very rife with takeovers, with mergers, with acquisitions. And we're seeing increasingly requests from companies to come to us and say, hey, we're looking at taking over this other company. We'd like to get a handle on the valuation of their personal data holdings. And obviously, personal data doesn't belong to the company. Companies are stewards of individuals' personal data, but in aggregate, that personal data absolutely has value. And we like to feel that we can help businesses to understand how to maximize that value in terms of fueling growth, reaching out through the social networks to bring in additional customers, and actually provide an objective valuation when it comes to discussing mergers and acquisitions. Now, Rob, I know one of your areas of passion is data governance, and I was wondering, what do you think are some of the special challenges around governance, particularly in this sector?
So yes, it is. Well, my passion's data, I think, in a nutshell. But from the governance perspective, yes. I mean, I think when this regulation came in, people focused a lot on ensuring that they sort of took on this concept of compliance and were compliant to the regulation. There's a huge amount. The regulation is there as a list of instructions. As primary legislation, it's there to be followed. But the governance around data is equally important, and the ability to be able to utilize that data for the benefit of the company is also important. Or else why would you have the data? The maintenance of it, however, is also paramount, because it goes back again to regulation of ensuring that the data that you hold about customers, even about employees. We talk about customers a lot, but employees also are personal data. is kept up to date and is kept current. And the ability for companies to do that is, again, it's down to how the systems work to allow you to actually maintain that. Because from a governance perspective, using clean data enables to be able to market, to be able to profile properly. And profiling isn't against the law; it just needs to be done properly. You know, is a benefit for the company, because once the data is cleansed, once the data is put in proper repositories, it can be marketed, it can be harvested, it can be used for direct marketing campaigns, and the output and the comeback from that, from your marketing departments, is that they're working with clean data that people have consented to be used for specific campaigns or services, and through the governance and maintenance of that data, it's beneficial. It becomes a beneficial thing. Putting all that into context, however, is timely and costly, and people always come back to that adage of time and cost. And also, this isn't going to happen overnight. And I don't think the supervising authority in the UK is expecting it to do that. I think what they're looking for is that companies in the UK are taking the concept of data protection seriously, and I'm doing the right things and making the right noises in relation to the compliance. And the governance is part of that. Governance forms part of that triangle. You've got the security element that Paul's mentioned from the cyber side. You've got the maintenance of the data and the transformation of that data, and then you've got the governance of it, how it's looked after and how it's maintained on an ongoing basis. The interesting thing is, and I'm going to pass this on to Paul, is where we see data protection legislation and legislation directives such as NIS clashing, or not clashing, but complementing maybe. I don't know. But Paul, what I was interested to find your view on where those waters are becoming, I wouldn't say muddied, but where one takes over the other.
Yeah, that's a really interesting area, particularly because energy sector is one of the regulated industries which falls into the operator of essential services, and that brings in additional compliance burdens, which coincidentally kicked in at roughly the same time as GDPR, but had a lot less publicity. But those of you who are working in the energy sector are mostly aware that the NIS directive, which was brought into UK law, means that there are additional reporting obligations. So under GDPR, for example, if you have a breach of personal data, you have a 72-hour window during which you have to report that, if it's above a certain level of seriousness, to the regulator. With the NIS directive, you've got a new set of additional regulators, and you've got to report breaches within 24 hours, and not just if they're relating to personal data, but if they represent a serious security incident which could compromise the effectiveness, the operation, or even attacking aspects of our national infrastructure, to regulators at different sectors. And that covers communications, energy, health, and other operators of essential services. So I don't really see those two laws as being in conflict, but there are slightly different emphasis according to what sort of sector you're in and what your focus will be. And probably there'll be different lines of responsibility and accountability within the organization for dealing with these different regulations. So that's certainly an interesting area. I wanted to also talk about something you touched on briefly, and that is the legacy environment, because data quality is important, and keeping the data up to date and accurate is one of the core principles of the GDPR. With legacy environments, you have a lot of old legacy data, and we're seeing increasingly more and more customers either are starting a migration to the cloud from their legacy environment, or if they're a startup, they bypass that legacy entirely and go directly into the cloud. And so there are certain challenges of ensuring that you have appropriate tools, technologies, processes, and policies in place to ensure you're protecting the privacy and the security of your systems as they migrate into the cloud. So one of the things I wanted to ask you, Rob, is what are some of the risks that businesses in this sector face in terms of their compliance journey, particularly when it comes to regulatory scrutiny? And I just want to mention, it's not just the scrutiny of regulators. You're also going to be scrutinized by your competitors in this space. And shareholders as well. There's a very interesting example of case law that's in adjudication at present. In the US, the ratings company Nielsen's is being sued by its major shareholders who claim that there were misleading statements made about the GDPR capability of the business, which, when shown to be incorrect, led to a significant drop in the share price. So it seems that there are these regulatory risks and also judicial risks, because you're the lawyer, not me, Rob. So what are some of the hazards that are facing people in this sector?
Well, I suspect there are a number of areas that if we were to put it in some sort of logical priority of order, one of the first things would be to ensure that process and policies and procedures are brought up to a standard that comply with the current set of legislation that's out there. Also, to add to that, there's a lot of you're dealing with a lot of third-party suppliers, a lot of third-party contracts in different shapes and sizes. And one thing the regulation makes very clear is that if any of your third parties are not compliant under the regulation, where personal data is being shared or processed, then they either have to become up to that standard, or you have to go and find somebody else to perform the same task. It is not an excuse or a reason if a breach occurred, whether major or minor, to say that it was up to the third party to make sure they were compliant. Unfortunately, it's up to you as a company to ensure that supplier is compliant, because you are the one that's supplying the personal data to them. And as a data subject, the expectation of that subject is that you are protecting that information as it travels down the chain. So process, procedure, and data protection principles are key. Education is also key. Your business is made up of people. People are probably one of the biggest forms of leakage of information. Not memory sticks, not paper being left on a desk. It's normally people, through discussions, through chats, through various discussions. It's people, and educating your people to a standard where they understand the importance of data protection is also key. So establishing regular types of educational seminars or webinars or SurveyMonkey type things is also quite important. Having a plan established to take you on that journey and continually maintaining that journey of compliance is probably one of the most key things, because it's recognized at the highest level the benefit and the importance of data protection, and that comes from the top down. So having that plan in place where it's manageable, usable, and have budget is also important. To be very clear, Paul was talking about some case law in the US. The ICO are becoming very I don't want to use the term aggressive, but that's the word I'll use, as I can't think of another one, in relation to ensuring that companies are doing the right thing. And there are two ways that the ICO will approach you. You will either approach them and ask them to come and audit you because you would like you would like their advice. You're transparent and open. You'd like their advice, or they have been alerted to your company because of a compliance issue, of which they will come knocking on your doors. And I don't need to go into the last, probably since May 25th, if not before, the last 6 to 8 months of news in relation to Facebook and other industries where data protection, data breaches, the concern about data protection has been highlighted. More and more so, this is what you're going to see. The interesting thing about the legislation is it's legislation. Until precedent begins to be built around that law and common law is established. And what I mean by that is that cases go to court, companies lose, it becomes a precedent. That precedent is then set. Therefore, any other case that comes with any similar function around it, that precedent would then take effect. So the output of that sort of case is pretty predictable based on that precedent. Now that hasn't happened yet in the UK. There's been a lot of fines been handed out over the last 6 to 10 months, but nothing's gone to court yet in relation to anything relating to the primary legislation of data protection. And until that happens, we are all still on an even playing field in relation to ensuring that we sort of do the right thing. But I won't go any further into legal stuff.
I just want to add to that, Rob, you may have noticed in the news this morning, it's the 25th of October today, the ICO announced, and you can find this on their website, that they've just settled on the maximum fine possible under the old legislation, the 1998 Act, for Facebook, who've now been fined £500,000 for some of their problematic data processing in regard to personal data in the last decade. So it's interesting to see that they're quite active.
So that was good negotiation on Facebook's part then, because that is the maximum fine that you were able to levy under the old act. And in fact, the only other company that was close to that, I believe, was Morrison's or Sainsbury's for their breach a few years ago, which was 450,000. So they always had very good lawyers not to be hit with the new regulation, which would have been substantially more.
Yeah, it's certainly an interesting business. Okay.
So I don't know if we're coming to the end of our session, or if indeed there are any questions from anybody listening in, and either written or please feel free to ask.
While we're waiting for that, I just want to mention that we're talking about data protection regulation that is going to absolutely continue after Brexit, because of course Brexit is top of mind for a lot of people in our sector, particularly if you've got a multinational business or you have business relationships with people on the continent. This question of adequacy that we were discussing before we kicked off today is a huge issue in terms of the transfer of data to third countries, the appropriate transfer mechanisms for third country data, and whether you can use model contract clauses or privacy shield if you've got US or Swiss links. All of these are really very interesting questions which are going to be exercising the mind of people as Brexit comes up. And I just wanted to mention some of the obviously, energy is something which doesn't necessarily cross international borders so much, but we see that, for example, the German privacy regulator has started random audits of businesses even without receiving complaints. They're actually conducting data protection audits just on a whim, it appears, in some of the Bundesländer.
Well, yes, I suppose you're right, Paul. The adequacy discussion we were having earlier is an interesting one, because as we were talking about standard contractual clauses that aren't even GDPR'd by the EU and being forced to use old clauses until they produce new clauses, but also waiting for the UK to exit the EU even before they're willing to discuss adequacy. So it is going to be a challenge for companies in the coming months, in the coming years, I think, at least the next 2 to 3 years, in relation to the concept of getting to grips with a regulation that we currently adopt because we're in the EU, paralleling that regulation once we leave the EU, but have to adopt standard contractual clauses that have been defined by the EU that we are not able to change in any shape or form within our contracts, but carry probably an old weighting that we then have to issue to any companies that we work with in the EU when we leave the EU. And then the third part is when the EU decides to offer an update to that and adequacy is still not granted to the United Kingdom, that we will have to redo that work again. So there are some very strange times ahead, I would hasten to add, in relation to the protection of data, and Brexit isn't by any means going to be helpful in that process.
Right. So before we wrap up, I just want to mention I haven't seen any questions come up yet, but if any do pop up in the next minute, we'll happy to look into those. So, Rob, do you have any final thoughts before we move on?
I expect I sort of probably just sum those up. I think it's interesting times ahead for companies who deal with people's personal data. I think the public are becoming more and more aware of the importance of that data. I will add one snippet that in the United States, we do talk a lot about the United States, but it's a pertinent thing that the United States, a lot of the NFL players, that's the National Football League in the United States, where their players are paid millions and millions of dollars. What these players have discovered is the importance of their personal data. And what I mean by that is their training regimes, their track history, their football history, how they train, how many minutes or hours it takes them to run 10K. And what they've done is they have begun to sell that personal data to apps like Strava. Strava is an app that if anybody out there runs will know it's a running and biking type app. But the interesting thing about this is that people are becoming aware of the importance of their information, not just for the point of its salability or the importance of the data itself, but actually who they will now trust to hold that data in the future. And you will see over the coming years a transition in relation to the protection of that information becoming more and more important.
Great. I think that's it from you, Rob, and that's it from me. So
thank you.
We'd like to thank everyone for their kind attention. This seminar will be available for download at some stage on our website. And if you do have any questions that you think of later, feel free to send them in to us. We'll be happy to talk about those and answer any questions you may have about the whole area of data protection. Thanks very much, everyone. Goodbye from me.
Thank you.
And
goodbye from him. Goodbye.